I'm here sui juris in propria persona. I reserve all rights. I, Jonathan Troy Colin Schuster, comma beneficiary and sovereign, and here under fraud, menace, and duress. Fiduciary advocate. This is a Social Security Certificate Trust action, which you are now a real party and interest to. I'm here sui juris in propria persona. I've challenged the jurisdiction of this court, and I don't understand. So I do need some questions answered. Is there a bond on this matter?
I believe you were PR. Actually, bail was set at $2,000.
There is a bond on this matter, correct?
Yes, there is.
Okay, and so is my social security number attached to these charges in any way?
I don't believe so.
You don't believe so?
I don't have any record of your social security number. So as far as I know, I don't know your social security number.
No, I'm saying, is my social security number attached to these charges in any way?
Only in the extent that it's connected to your driving history.
So is that a yes or a no?
In some way, shape, or form, your social security number is in the system with records on you. That is true.
Okay, so you just told me there was a bond, which means this is commercial court.
It's not commercial.
Now you're saying that my social security number is attached to these charges. And so, which means this is assessed a case trust action, which you are a real party in interest to. And I just told you I was the beneficiary. You're supposed to be charging the trust. You're not charging the beneficiary. And if you're creating bonds against my trust without my permission, I don't understand. Are you...
All right, everyone, buckle up, because today we're diving into the courtroom chaos of Jonathan Schuster, a self-proclaimed sovereign citizen from Washington who's convinced he's above U.S. law. He's claiming American Samoan citizenship, challenging the very jurisdiction of the court, and even trying to dismiss his own case before it begins. We're talking about a man armed with scripts, legal jargon he barely understands, and the audacity to argue that Social Security numbers somehow don't apply to him. By the end of this video, you're going to witness everything from bizarre claims of fraud trust to jaw-dropping courtroom tension that's as frustrating as it is fast.
He's not speaking for you, but I am asking him a direct question, so I need you to let him answer.
Okay.
Yes, so the court did appoint us on this matter, but it sounds like he does not want my office to represent him, so I'm happy to withdraw.
You can dismiss yourself.
So would you like to represent yourself in the matter, Mr.
Please
Schuster?
do not tell me to shut up. You can dismiss yourself.
So he can't dismiss himself, only I can dismiss him. I'm asking you if you wish to have an attorney or if you wish to represent yourself.
This is a trust or certificate trust action. And so I'm here sui juris in propria persona. You know what that means. And so we can prove.
Don't know what it means because it's nonsense, but nonetheless.
Prove jurisdiction, or we can dismiss this matter with prejudice.
So I'm not going to do that today. Here are your choices. You can have Mr. Parent represent you. You can choose to obtain private counsel, or you can represent yourself. Let's start there. Which of those three?
Nobody's going to represent me. I can present myself, as I said.
So you wish to go pro se? I don't need you to read the script. I need you to tell me if you wish to go pro se.
I told you I'm here sui juris in propria persona.
Ms. Roberts, are you there?
Yes, Judge.
My inclination is to set this matter over and see if Mr. Schuster wants to give it another shot with his attorney or go pro se. It looks like this is the first pretrial. I suspect he's not prepared to set for trial today.
What is the first one? There's no plead.
Okay, I'm not speaking to you, so you're gonna have to wait. I'm speaking to Ms. Roberts.
I mean,
Judge, I would ask that we set this matter over 1 week.
Okay. Do you want to come back to court in 1 week and try again?
we can finish this matter now.
We
There's
can't.
no need to
We
move
can't.
this any further because
So here's
it's
the
not
thing.
proven jurisdiction.
Here's the thing. It's not my position today to have to prove jurisdiction to you.
It is. It is your position because
It's
it is
not.
on the courts.
And I'm also not going to argue with you.
There's no
So
arguing.
I'm going to have you come back to court in 1 week.
There's nothing you can prove that you have jurisdiction. This man does not speak for me.
So we're going to come back to court on July 1st.
That date doesn't work.
Why doesn't it work for you?
Here's where it gets really wild. Schuster immediately starts claiming that the court has no jurisdiction over him because he identifies as an American national, not a U.S. citizen. He throws out phrases like fraud trust and sua juris appropriate persona, try and create a legal loophole that, frankly, doesn't exist. What's important to note here is how he repeatedly asks whether his social security number is attached to the charges. This is classic sovereign citizen behavior, questioning basic legal procedures and suggesting that regular court rules simply don't apply to him is both confusing and a little entertaining. Watch how the judge keeps calm while Schuster's logic spirals deeper into legal fantasy land.
You violated my rights enough.
We'll just hold Speedy for
You
this week, Ms.
violated my
Roberts.
rights enough. This matter needs to be dismissed with prejudice,
We'll see you back on July 1st,
or else what? You're gonna threaten me?
or else the court will issue a bench
So
warrant.
you're threatening me now, Abigail.
I am telling you your
No, I'm telling
options.
you, this matter needs to be dismissed with prejudice. Because you cannot prove jurisdiction. This is a
Signature here.
substitute trust action.
Signature
You're
here,
trying
please,
to
sir.
commit fraud.
Sir,
You're
Mr.
trying to
Schuster.
commit fraud. Miss, I'm
So-
speaking with Abigail.
You're done.
No,
you're
no,
done.
you can't tell me I'm done.
I
This
can.
is no, you don't have power to do that.
Your court case is
You
over.
don't have power to do that.
Sir, your hearing is over. If you don't take your paperwork and leave the courtroom, we'll have you remanded into custody.
You're threatening me now,
I'm
even more so
Giving you
than
a
already
choice.
were.
We can address Jonathan Schuster, 480525748.
For the record, this man.
Why don't you come up to council table, please, so we can create a record?
No, I don't want to and give you any personal jurisdiction, so I'll stay right here.
No, you'll come to the council table if you would like to be heard and make a record. So you need to come up and turn on the microphone.
No, I don't need to do that for me to be heard.
We are audio recording, so to be heard, you need to come up to the table and sit with the microphone.
You don't have to, I don't have to come up there for you to hear me. You can hear me perfectly fine.
I can hear you, but we are creating a court record, which is audio recording.
Jurisdiction by doing what you said, because you don't have jurisdiction over me. And so, for the record,
Mr. Schuster,
I reserve all rights.
I did put Mr. Parent as standby counsel. Right now, you don't represent yourself. You have standby.
Now pay attention to this part. The judge confirms there's a $2,000 bond and tries to explain how Social Security numbers relate to court records. But Schuster twists it, claiming that if his number is in the system at all, the entire case must be commercial court or some trust-related action. He's essentially using technicalities to try to invalidate the charges. This is a good example why courts have rules. When someone attempts to argue jurisdiction based on misinterpreted administrative details, the judge has to stay firm, ensuring the case moves forward despite all the theatrics.
Miss Jennifer. And so I have some questions for you.
Well,
Are
right
you
now,
able to answer them?
I am not here to be interrogated by you. You are
Well, I
under the
just don't
jurisdiction
understand
of this.
what's going on here.
I think you understand and you choose not
I
to
do
take
not
in the information.
understand
Okay,
what's
well,
going on
Mr.
here.
Schuster,
I don't understand the nature and cause of what's going on. I don't understand how you can practice law from the bench. I don't understand how you can appoint counsel when I've told you over and over and over again that I'm here sui juris appropriate persona. I'm here of my own right in my proper person. He does not have my permission to represent me in any way.
well, it doesn't sound like you know how to represent yourself either,
I
which
need
you
to
would,
represent myself.
well, you would. Either
No,
you
I
have
don't.
counsel or
I need
you
to
are acting pro
represent
se.
myself. And so, like I have told you, I'm here sui juris appropriate persona. I have challenged the jurisdiction of this court. You have not answered that challenge. We cannot move any further until you've answered that challenge. Is this common law jurisdiction or is this an admiralty maritime jurisdiction?
Either. So,
right.
Mr. Schuster, this is Carmen McDonald. I'm the prosecutor on this particular case. I think where we're at right now is you're being charged with an offense. I can barely hear you, which means the record that you're trying to make is not being picked up and not being recorded. So everything you're saying is not being preserved unless you go to the table up there near the microphone. So that's number one.
For the record, I
If
reserve
you
all
would
my
like-
rights. If you
If
cannot,
you would like,
I will
if you,
step up so you can hear me better, and I will
none of
speak
it's being,
louder.
none of it's being
I will
preserved.
speak
until you-
louder so you can hear me, but I reserve all my rights. And I'm speaking much louder than anybody else prior to me has spoken.
Mr.
So I just want to make sure that
Mr.
the reporter
Schuster,
can hear me.
you are making legal arguments. All right, you are making legal arguments. They should be preserved for the record, which means it needs to be picked up and recorded.
I will
So-
begin again so that the recorder
You're
can
not
hear me.
choosing to be silent, you're choosing to make a legal argument, so we need to have that on the record.
For the record, I reserve all rights.
You've made that,
I, Jonathan, Troy, Faifo, Leaso, Malia Toa, Colin, Schuster, have made a special appearance under fraud, menace, and duress. Fiduciary, Jennifer. I've challenged the jurisdiction of this court.
Here comes the classic drama moment. Schuster refuses to have an attorney and insists on representing himself. The judge lays out the options: private counsel, public counsel, or pro se representation. But Schuster's constant interruptions and insistence on reading his script make it clear he isn't prepared. This is where courtroom patience is tested. Notice how the judge repeatedly tries to clarify. It's not about silencing him. It's about keeping proceedings orderly. And yet, Schuster keeps pushing, claiming he's being threatened and asserting that the court must dismiss the case. The tension here is palpable. It's a mix of comedy, frustration, and real legal consequences.
I understand that the city's bringing up whether or not you're able to proceed in this matter. So whether or not you're able to understand the nature of the proceedings and be able to assist your attorney or to represent yourself, you have to be able to meet that threshold.
I'm
And the
here.
fact that I think it's not that you don't understand, I think it's you choose not to understand, and that you have someone giving you information that you are spewing in court. So you're simply off base, but I don't know that it's due to a mental defect
we cannot
that is
move
causing you
forward.
to not be able to
To
understand.
challenge my competency, because I have challenged the jurisdiction of this court,
we're
and you
not
have not
dealing-
proved
We're not dealing
jurisdiction.
in social security or contracts
You
or
have to prove
maritime.
jurisdiction before we can move any further.
So that's just not how it works in this court, and
No,
I don't
that's
think you
how
have
it
the
works.
legal.
You must prove jurisdiction because I've challenged the jurisdiction. If you cannot prove jurisdiction, then I move to dismiss this matter with prejudice.
That's denied.
And so, Jennifer, Miss Jennifer, can you
I'm
prove
Judge Grant, so I'm going to
Jennifer,
have you,
can you establish the jurisdiction? Can you prove jurisdiction?
Ms. McDonald. I don't know that this is him not understanding.
I do not understand the nature or cause.
Well,
of
he doesn't have legal training, so that I think is.
that does not
clear.
matter.
Well,
If I'm here sui juris and propria persona, I'm of my own right. I'm in my proper person. You've created a bond on this matter. You've attached my social security to this matter. You're trying to charge my trust without my permission, which is illegal. It's fraud, and I'm not going to stand for that. So you must prove jurisdiction before we can move any further. You've already tried to practice law from the bench, which is illegal. You cannot do. You've tried to assign counsel when I've given no power of attorney to anybody.
The judge finally sets the next court date for July 1st, and Schuster immediately escalates, claiming threats and demanding dismissal with prejudice. It's almost like watching a legal soap opera. He talks about bench warrants, duress, and being mistreated, yet he refuses to follow the court's instructions. This segment highlights an important courtroom reality. Claiming rights doesn't override court procedures. Schuster's failure to provide a valid legal argument means the case continues, and his theatrics only delay the inevitable. For viewers, this is a great example of how far some individuals will go in sovereign citizen arguments, and why judges have to be firm but professional.
participate in that process either.
Right. No, I understand
We have
that.
speedy trial at
It is the
August
burden
9th.
of the state to prove jurisdiction. The prosecuting attorney has not done that. And so what we have here is we need to dismiss this matter with prejudice. And I motion to dismiss this matter with prejudice.
Denied.
Based on the fact that the prosecuting attorney has not proven jurisdiction.
Mr. Schuster, would you like to sit at this table away from council so that we can hear you on the
This isn't
microphone?
counsel.
Well, you could sit at this table if you'd like. There's a pen and a form and a microphone for you if you'd like.
We cannot move until jurisdiction has been proven.
Yeah, this should be a,
You have failed to prove in jurisdiction.
Jurisdiction is something that we prove at trial. It is a factual issue as well.
We cannot move any further until jurisdiction has been proven. And none of you have done that.
So Mr. Schuster, did the court say that was August, end of August, or?
it was August 9th is speedy trial.
So
And if you plan on having me back here, you're taking away from my ability to.
Next up, Schuster refuses to come to the council table or use the microphone, insisting he doesn't need to be recorded to be heard. The judge, wisely, insists that everything must be on record for legal purposes. This is a key teaching moment. In any court, if statements aren't officially recorded, they essentially don't exist in legal terms. Schuster's stubbornness is entertaining, but also underscores a practical truth. Court procedures exist to ensure fairness, clarity, and accountability, not to stifle your creativity in making legal arguments.
All right, so Mr. Schuster, you've been charged with driving while your license was suspended in the 3rd degree and for operating a vehicle without the required ignition interlock device and refusing to comply with law enforcement officer. You are on a deferred prosecution in another court, and the consequences are extreme for you. You are subject to another court, and they could very well
get in trouble. And you have to prove jurisdiction. You haven't done that, and you failed
obviously
to do that.
you believe that courts do have jurisdiction over you.
Obviously, you have to be able to prove it, and you haven't. And you can keep pushing it and doing this, but it's just a waste of time for everybody. I definitely understand that this is not what you think it is. And this is just a waste of time at this point. So whatever you need to do to prove jurisdiction, but I know you can. So if you want to waste more of everybody's time, go ahead. Because obviously I'm not going to allow you to threaten me anymore.
Now watch as the prosecutor fires back with a reality check. Driving on public roads creates a social contract with the government, linking Schuster to the law whether he likes it or not. He can't just opt out of statutory obligations because he prefers a different interpretation. The contrast here is fascinating. Schuster's convoluted legal theories versus the clear, practical application of law. For viewers, this is where the comedy and education collide. The sovereign citizen mindset meets the immovable reality of the legal system. You can almost see the frustration building, but the court keeps moving.
Your Honor, just set it for trial today with an intervening pretrial. Provide him with that document and enter the waiver at the next hearing prior to allowing counsel to withdraw.
All right.
Counsel should have never been appointed because I've never gave my power of attorney to this counsel. And obviously you did that to practice law from the bench, Miss Jennifer, which is illegal. You cannot do that.
Mr. Schuster, you're charged with a crime that has potential jail consequences and fines. And so your rights need to be protected. This is for your benefit.
There is no injured party. There is no sworn complaint of an injured party. This is absolutely ridiculous. It's a waste of everybody's time. And you're taking away my ability to work over and over and over again. You're proving that you don't have any jurisdiction.
So this is a detailed advisement should you wish to waive your right to have counsel present and you want to act as your own attorney.
I said over and over again that I'm here sui juris and propria persona. You know what that means.
This case is going to be going to trial, so you need to have counsel.
I'm here of my own right and my proper person. You know what that means.
So there's the form.
I've never signed my power of attorney away to anybody, especially this.
You need to be respectful. You are really out of line, Mr. Schuster.
I didn't say anything disrespectful.
You are being
This
very
person-
disrespectful.
You
to
were
the
being very
court.
disrespectful, actually,
the court
because you
and to Mr. Parent.
you're violating my rights.
So I'm
forcing
going
me
to set
to
this on
come
for the
in here
August term. I'm going to have you take this form.
Wasting my time.
Mr. Schuster.
When you're taking away my
I'm going-
ability to provide and work. Because
Have a
this is
seat there so
free-
you can fill out
free
this
place.
form.
What's that?
You can have a seat there so you can fill out the form.
So to wrap this up, Jonathan Schuster's attempt to dodge the law with self-styled legal jargon, claims of American Samoan citizenship, and argument about fraud trusts were firmly rejected. The judge set the next hearing, clarified that he must be represented properly or follow pro-issue rules, and ensured the record captured every word. This case is a masterclass in courtroom patience, legal reality versus fantasy, and why procedural rules matter. If you found this case as shocking or as bizarre as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping breakdowns of real-life courtroom drama.